Hello, welcome, and good evening. Good evening to all of you for this today's topic, which is basically on the international tax, the recent developments through judicial pronouncements. So, in next 55 minutes, we will discuss about whatever the changes or whatever the recent developments that have been made through these judicial pronouncements by the various courts. So we will discuss all the things, and in next 5 minutes, in the last 5 minutes, we will take the Q&A, if any. So these are the 5 judgments that we will going to discuss in the today's session. The all these 5 judgments are pronounced by the Delhi High Court. So one is relating to the Progress Rail Locomotive. Second one is the Hyatt International Southwest Asia Limited. Third one is the International Management Group UK Limited. Fourth one is the Telstra Singapore PT Limited. And fifth one, which has been just recently announced 15 or 20 days back, the Tiger Global International Holding. So these 5 judgments basically will fall into the 5 topics. So we will correlate this judgment with the 5 topics. So first is relating to the existence of the subsidiary, how a can subsidiary can be treated as a P in India. So this is the one of the area that we will touch upon. The second thing we will discuss about the allocation of the business profits, how the business profit will attribute to the P at an entity level or at a P level. The third one we will going to discuss about the interplay of the business profit vis-a-vis the royalty. And if suppose one item as a composite contract is being there, how can we assess the same into the business profit, or how we can assess as a royalty? And in the same part, we will discuss about the make in available clause as well, how the make in available clause will be crucial for taxing the royalty part is concerned. Then the fourth thing we will discuss the interplay of the royalty. If suppose changes has been introduced in the domestic law, how the domestic changes in the domestic law will going to impact the DTAA or the treaty as well. So this is the fourth thing that we will going to discuss. The fifth one we will going to discuss about the beneficial ownership concepts under the interest, royalty, and fees for technical services. TRC, the relevancy of the TRC tax residential certificates and the grandfathering provisions of the capital gains. Just to start with these judgments, so let me give some overview about the international taxation. So I will spend just 2 minutes how the international taxation works about. See, the Income Tax Act, particularly for this non-resident Indians, which we can say that the NRI. So section 4 and 5 is the charging section, right? So section 4 is the charging section. Section 5 tells about the scope of the total income. So for the residential, the status of the residential of India as in residential Indian, we can say that the global income is going to tax in India. But for these non-residents, if the source of income are based in India, only and only the tax authority can charge the tax. So section 5 says that if the income is receiving in India or accruing in India or deemed to accrue or arise in India, right? So this is for the particularly for the non-resident Indians. And section 9 is also the charging section for these non-resident Indians, which says that in what circumstances the income will be treated as a deemed to accrue or arise in India. Section 90 of this Income Tax Act says that the assessee has a choice to tax under the treaty or under the tax law, means the under the Income Tax Act. Section 90 says that if a person want to get the benefit of the DTAA as well, so he can do it. So that means under this Income Tax Act, if a person want to get assessed under the DTA, so we need to know about what are the DTA provisions, right? So like in case of the section 9, which says that the business connection should be there. So that means business profit should be taxed only and only where the business connection is there as per section 9. But under DTA, there is no concept of the business connection. There is a permanent establishment connection. So, right. So permanent establishment, if the permanent establishment or the P is in India, only and only in that case, the business profit will be assessed in India. Otherwise, the business profits are not going to tax in India. So this is the framework of the international taxation. So for this today's session, so I have made a PPT in such a way that all articles are interrelated. Whatever the judgments, whatever the contents that can be related to these judgments, I have made in a synchronized way. Like the Article 5 tells about the permanent establishment, right? So this one judgment, which is relating to the existence of the subsidiary, can be treated as a P in India. So that means it will be covered by the Article 5. The second thing we will discuss about the Article 7, which is the business profits. This is the second one. Third one will be relating to the royalty. So how a business profit or a royalty will come into play, right? So royalty article would be 12 or 13 of the respective DTAs. Interest, royalty, and the FTS, there's a beneficial provisions. If a person want to assess under the DTA, and if he's a beneficial owner, he can avail the reduction of rate as per the DTA. So that means we need to know about how this article works about, right? So there's a separate segment of this article 12, 11, 12, and 13. So we will discuss in the Tiger Global. Fourth one, we will discuss about if there is a royalty, article 12. If some changes has been introduced in the domestic law, how a domestic law will play a crucial role in defining the DTA, right? So I have made this PPT presentation in such a way that all articles we can connect with each other. Now let's start the discussion for this today's session. The first judgment that we are going to discuss is the Progress Rail Locomotive, which has been pronounced by the Delhi High Court. The brief facts of the case are the assessee is the US based company and it has a subsidiary in India, right, in the Varanasi. The business of the assessee was to provide a solutions to the railway, uh, Indian railways, including some manufacturing equipment they are supplying directly to the Indian railways. Now, the Indian subsidiaries was also supplying some material or providing some solutions to the Indian railways. A survey was happened at the at the premises of the Indian subsidiary. So question was raised, why not the subsidiary will be treated as a P of the foreign company? So by analyzing all the facts, the court has given a very good judgment in what circumstances a a subsidiary can be treated as a PE in India or not. So this subsidiary and the PE relationship covered under the Article 5, right? So Article 5 tells about the permanent establishment. So now we will spend some time on the understanding of the concept of the permanent establishment just to get a detail how a subsidiary can become a P in India. So Article 5 tells about the permanent establishment. So I have highlighted some parts. I'm not going through all the facts of the permanent establishment. I will discuss about only the crucial part which has been highlighted or which has been discussed in the judgment. So for this permanent establishment in India, the permanent establishment means a fixed place of business through which the business of the enterprise is wholly or partly carried on, right? So it means it has given an exhaustive definition of the PE by the DTA. The second thing is that the permanent establishment includes, so it has given the inclusive definition as well. So first A part is saying that it is a means through which the business of the company is carried on through this permanent establishment. The second thing is say that it has given the inclusive definition by stating that it includes a place of management, branch, or an office, or by furnishing of services other than the included services as defined in Article 12 means royalty. within a contracting state by an enterprise through employees or other personnel, but only if some period of time has been spent by a particular person or particular employees to the another entity. So in that case, the services PE will get created. Or the services are performed within a state for a related enterprise, which has been covered by Article 9. And the clause 3 of this Article 5 has specified that in what conditions, or what are those conditions in which the P will not be treated as the company will not be treated as a P in India. Like in case of, if suppose a particular entity is doing a business just for collecting the information, or just collecting or pass through the information to the other enterprise, in that case as well, the same will not be treated as a P in India. Or the maintenance of fixed place of business solely for the purpose of advertising, for the supply of information, or for scientific research or other activities which have a preparatory or auxiliary character for the enterprise. So that means in that cases, if we are supplying or collecting the information, in that cases, the entity will not be treated as a P in India. The fourth category is the dependent agents and the independent agents. A person is acting in the contracting state on behalf of the other contracting state shall be treated to have a P in the first mentioned state where he habitually secures order in the first mentioned state, wholly or almost wholly for the enterprise. If suppose a person is working on behalf of the other enterprise, wholly or almost wholly. Wholly means more than 70, 80% or 90%. We have to prove. This depends on fact to facts or case to case basis. If a person is particularly working on behalf of the other enterprise, that person will, so that means the other entity is dependent on the first entity. So in that case, the dependent agents P would get created. So we can define the P into three ways. First thing is that it's a fixed P which has been defined through Article 1, Article 5, Clause 2, and Clause A to K. So is the fixed P. Second criteria of the P would be the service P, wherein some employees or the personnel are working for the other entity, provided some conditions or some criteria of the number of days are fulfilled. In that case, the services P would get created. The third thing is that the dependent agents. If I am working on behalf of the other enterprise and doing work almost wholly for the other enterprise, so that in that case as well, the dependent agents, the day P would get created. So what were the arguments raised before the High Court? So the first argument raised was that the one is the foreign company, another is the Indian subsidiary, wholly owned Indian subsidiary. So the first argument raised was there was a distinct line of products manufactured and supplied by the petitioner and the Indian subsidiary. So that means I am doing a separate business, my Indian company is doing a separate business. The second thing is that the second argument was that the petitioner was not having a control or oversight over the factories or the offices of the Indian subsidiary. The third thing was the Indian subsidiary was not playing any key role in relation to the core activities of the parent company. Core means if I am into providing a solution to the Indian Railways, I am not into the role which we can say that correlated with the foreign company or to the petitioner company. The fourth argument raised was the petitioner exercises no lien on the employees of the Indian subsidiary. If some employees are visiting to the Indian subsidiary just for the quality control or for some shareholding activities, that can't be say that or that can't be treated like that the Indian subsidiary has a control over the employees of the foreign company. Next, the mere existence of a wholly owned subsidiary would not ipso facto amount in assumption of the P. So that was held by the e-solutions by the Supreme Court. So mere existence of the P doesn't mean that a P would get automatically created. So that doesn't a scenario. A parent company's activities abroad as a shareholder in other companies can't create P. If suppose some shareholding has been held by the parent and the subsidiary, that obviously the shareholding activity would be there. So that doesn't mean that the subsidiary would get automatically become the P of the foreign company. The next one, which is a very crucial one, subsidiary P may come into existence where it is found that both entities are in fact alter egos and undertake joint business activity. So that means if a foreign company and the Indian subsidiary are doing activities just as an in continuation of their particular business as a joint business activity, in that case, the P can be created. The subsidiary can be treated as a P. Otherwise, not. If I am doing a different line of business, my Indian subsidiary is doing a different line of business, my foreign company is doing a different line of business. So in that case, that the Indian subsidiary can't become the PE of the foreign company. The next argument raised was the subsidiary can give rise to PE if the subsidiary allows the parent company to operate from its premises such that the primary test is of the Article 5(1) is satisfied. That means that the disposable test should be there. So that means I have a right to dispose of your business. I have a right to control your business, as held by the Supreme Court in the Formula 1 judgment, wherein it stated that the disposable test should be need to be satisfied to come under the criteria of the permanent establishment. If not, the P would not be the subsidiary would not be treated as a P. When the subsidiary is merely an alter ego of the parent, being entirely dependent on the parent for its survival, it may result in the virtual projection of the foreign enterprise in India, thereby creating a P in India. So that means if I am wholly and only dependent on my foreign company, in that scenario, the situation can arise that the Indian subsidiary will be treated as a PE of the foreign company. So what are the findings which has been given by this Honorable High Court? The first thing, the court held that a subsidiary would be deemed to become a P only if he satisfies the test laid down in Article 5, Clause 1, 2, 4, and 5. So that means we need to check all the criteria, means whether I am falling under the fixed P criteria, that means my disposable test has been whether I am meeting the criteria of the disposal test. I can dispose your business, I can control your business. So this is the one thing. So that means the court tells that mere existence of the subsidiary doesn't mean that a P would get created. So we need to check all the facts in the Article 5. Like the fixed P, this is the number one. Second thing is that if suppose the service P situation, so that means accept this quality control and the shareholding activities. If some relationship can be created, like the employees are visiting and they have uh, uh, fulfilled the criteria of the 90 days or the period which has been defined in the DTAA, that can be created the P in India. The third thing was that if a subsidiary is doing a business on behalf of the foreign company for wholly and almost wholly business. So in that case, the dependent agents P can be created for the Indian subsidiary. So that means by mere existence of the subsidiary, we can't say that the P would get created. So in that way, the court has analyzed all the facts, whether the service P for this scenario, if the employees are visiting, so whether the service P can be created. So court held that, okay, the normal activities or they are doing the quality check and the contribution activities, we can't say that the service P can be created for this scenario. The second thing, the court has defined that in what conditions the fixed P can be created. So court has defined some criteria by taking the reliance from the other judgments like the Formula 1 and the DTA commentaries as well. So first thing, the court has defined that the first function of the term through is to make it clear that the taxpayer has control the P. As long as the space in the establishment or the premises placed at the concert disposal of the enterprise, it would satisfy the test of the fixed place P. So that means I have a full control over the subsidiary's place of business. In that case, I can say that, okay, the the fixed place P can be created, otherwise not. So in that case, the factories was established in Noida and Varanasi for the Indian subsidiary. So there was no any facts which can be proved that the Noida and the Varanasi, or we can say that the Indian subsidiaries business was controlled by the foreign company. So we can't say that the criteria of the fixed P is meeting out. So the third thing which the court defined, that the subsidiary was taking their decision with their own right, means they are taking the independent decisions. They were not dependent on the parent company. So the fourth thing was that this was therefore not a case where the subsidiary stood created solely for the purpose of the undertaking activities and discharging function concerned solely with the core business activity of the enterprise for the petitioner. So that means in that case, the court observed that if I am providing a solution to the Indian Railways and providing some material to the Indian Railways, and the subsidiary is also providing the solution and the materials directly to the Indian Railways, so both the entities are doing their business in their own way. So that means we can't say that the Indian subsidiary is taking instructions from the parent company or the foreign company. If we can prove that, okay, if the if the subsidiary company is taking in instructions and doing business on behalf of the foreign company, in that case the court has said that, okay, in that case we can say that the P would get created, otherwise the P will not be created in that scenario. The last thing the court mentioned, that a subsidiary P could be said to have become a mere alter ego, provided it were found that it had no independent business activity to undertake or work only to subserve the business interest of the petitioner. So that's the same thing. If I am doing my own business, so the foreign companies are also doing their own business. So that means we can't say that there is any activity which can be correlated. If it can be correlated, so in that case, yes, some sort of the P would get created. Lastly, the court held that for the fixed P part, if some backend of operations were handed over to the Indian subsidiary as held in the e-fund solutions by the Supreme Court, the back office operations would not be treated as a P in India. Like suppose in that case, if I am collecting the purchase orders or following the purchase orders, or just to remind the customers about the collections part, which is not a core business activity, we can say that. So this back office operations would not be treated as a P in India. The court has analyzed the another aspects like the auxiliary and the preparatory services, like whether I am doing this core activity or non-core activity. So if I am doing the core activity, definitely the P would be there. If I'm doing some preparatory or auxiliary services, like I am following the purchase orders or supplying the purchase orders, or we can say that I'm just supplying the informations or medium of communications to my foreign company. So that means I can't say that I'm doing the core business activity for the foreign company. So I am doing just the preparatory part. So in that case, I can say that no P will get existence in India. Dependent agents analysis, the court observed that both entity were doing their business in their own way. So there's no any dependency of the Indian subsidiary on the foreign company. So we can say that the any sort of the P would get created in India. So the conclusion of the judgment was the main thing was that if I am doing a joint business act, like in India's many corporates or many Indian subsidiaries who are working for the foreign company, if they are doing the joint business activities, like if some order has been received by the foreign company, and in continuation to that order, if the Indian subsidiary is also doing the same business in India, in that case, the P would get created provided all conditions of the Article 5 are fulfilled, like fixed P, service P, or the dependent agents P. So all thing we need to take care of while doing the analysis of the subsidiary companies P whether the subsidiary can be created as a P in India. So that was the judgment which have in which the thoroughly the P concept was discussed. So that was the first judgment relating to my to do this my first judgment first discussion. The second thing we can take this, the next judgment is the Hyatt International. So after analysis of this Article 5, this judgment is relating to Article 7. Article 7 says that the business profits allocation to the P. So there was a controversy about how a profit can be attributed to the P. So P is covered by Article 5. Article 7 tell about the allocation. So there was a judgment called Nokia solution by this Delhi High Court in 2023, wherein it was held that the allocation of the business profits to the P would be at the entity level. Suppose at the entity means at the company level. If suppose at the global level or the entity level, the company is having a losses, so that means there will be no profit, there will be no allocation to the P in India. Might be that the Indian P is generating some profits. So that was a controversy. And this Nokia solution was based on the Motorola by this ITAT bench. So this matter was referred to the full bench of the Delhi High Court, whether the profit attributable to the P would be at entity level or at the P level, right? So that was the discussion was happened in this case of the Hyatt International. So Article 7, so I have mentioned the relevant extract of this Article 7 and highlighted only the in the blue area for this judgment purpose. The profits of the enterprise, the clause 1 says that the profit of the enterprise of the contracting state shall be taxable only in that state unless the enterprise carries on the business in the other contracting state through permanent establishment situated therein. If the enterprise carries on a business as aforesaid, the profits of the enterprise may be taxed in the other state, but only of so much of them as is attributable to that permanent establishment, right? So P would be there. The profit, unless and until the P is in existence in India, the profit can't be attributed. This is the first rule. No P, no profit, no tax in India. Once a P is in existence, how the profit would get allocated? The clause 2 says that subject to the provisions of the paragraph 3, where the enterprise of the contracting state carries on the business in the other contracting state through a permanent establishment situated therein, there shall in each contracting state a attributable to that permanent establishment the profits which it might be expected to make if it were a distinct and a separate enterprise engaged in the same or similar activities. So this is the crux of this article is that the P would be treated as a separate and distinct enterprise for the allocation of the profit. So that was the interpretation which has been given in this judgment. So we will discuss this. The arguments which was raised by the assessee in the court were relying on the Nokia judgment. So no income attribution can be made under a treaty when the foreign entity's overall global operation result in a loss. So that means the assessee's proposition was that the profit attributable to the P should be at the entity level. If it's a losses at the global level, no profit would be attributable to the India. The second thing the proposition was the profit is a precondition for the profit attribution. If the entity incurs a global loss, then no question arises of attributing any profit to the P, which would be taxable in India. So the assessor's contention was to allocate the profit at the entity level. The Nokia judgment was basically uh, based on the Motorola incorporation, the same rule was applied over there. The profit should be at the global level. So what are the findings by the court? How this judgment of Hyatt International was different than the Nokia, because this Hyatt International was referred to the full bench. So three judges has given the judgment of this Hyatt International. The court observed that why the profit should be at the P level rather than at the global level. What are the reasons and what are the findings which has been given by this honorable court? The court emphasizes that profit should be attributable to the P as if it were a distinct and a separate entity, engaged in the similar activities and independent of the enterprise of which it may be part, which has been mentioned in the Article 7 itself. Clause 2 says that it will be treated as a distinct and separate entity. The court has specified the same thing. If it's a separate and distinct separate entity which has been mentioned in the article itself, why the profit should be attributable at the global level? Right. So the court has given a clarity on that point. The court recognized that the P constitutes a separate source of profit, and it is incorrect to ignore the income generated by the activities undertaken by P in the contracting state. So that means by applying the Nokia judgment, if suppose Indian P is generating a profit, right? But the global level, it's a loss. So that means the Indian tax authority doesn't have a right to tax its own P, which is being generating the profits for the Indian company. But the in the Nokia it said that it should be at the global level. So the court recognized the same thing, that P constitutes a separate source of profit. Article 7 doesn't tell about to reach the overall operation of the profitability of two-way transaction entity. The taxability of the income earned by the P existing in a source country is not even remotely linked or coupled to the overall operation of the entity, because Article 7 specifically tells about that it should be treated as a distinct and a separate entity. So the court held that the Motorola case as well as the Nokia case was misconstrued. The court held the further reasoning that if Indian P is generating a profit and if we allow the same at the global level, it doesn't make any sense, right? So Indian authority should have a right to tax whatever it has been sourced from India. The court has given this finding by interplaying between section 5 with the DTA. Section 5 says that for the non-residents, whatever the source from India, the Indian authority have a right to tax, right? So that means if a P is generating a profit in India, if we apply the logic under Article 5 as well, so that means the taxability should arise at the entity at the P level. And the Article 7 also says that it should be treated as a separate and different as a distinct entity. So that means by applying the same concept, the court held that the profitability should be at the P level rather than at the global level. And court has relied on the commentaries of OECD and the UN commentary, which has specifically tell about that the taxability should be from the source rule, should be taken from the source rule, and it should be taken at the P level rather than at the entity level. So this judgment has clarified the fact that Article 7, which tells about the P should be treated as a separate and distinct entity, and correlating the fact with the Section 5, which says that the source country, the for non-residents, the taxation would be from the source from India, not at the global level. So that was a very factful finding given by the court for this judgment in the Hyatt International. So after covering the Article 5 and Article 7, so we are now going to discuss in the third judgment, which is the name is International Management Group, how Article 7 and Article 12 will interplay, This is the first thing. Keeping in mind that the Article 5, Article 7, and Article 12 of the, which is based on the royalty. So this International Management Group, UK Limited, this is the third judgment pronounced by the Delhi High Court. The brief facts are, the assessee, which is the International Management Group, was associated with the BCCI for organizing the IPL matches in India, right? And they have got some payment from BCCI in terms of, we can say that the advisory and management services for providing some research and organizing the IPL events in India. In 2014, when the elections were held, some IPL matches was organized in South Africa and Dubai. Some sort of fees was paid in from the Dubai itself. So that was a composite contract in that case. The assessee is a P in India. There's no dispute about that. And the tax department has accepted that, okay, it has a P in India. Some profits attributed to the P in India. Some profits which was in the nature of the royalty in terms of advisory services. The question was arises how to tax the advisory services, keeping in mind that I have a P in India. Second thing, so these are the 3 points which has been raised. Second thing, if it's a royalty, whether I am fulfilling the condition of the make available clause, right? So the court in a thoroughly manner has discussed this concept of the make available. The third thing, the IPL matches was organized in Dubai and South Africa, which was, so that means from outside India. The court has done an interplay of Section 9, Clause 1, Subclause 7B, vis-a-vis explanation of Section 9, which says that if I'm providing a services, or if I'm availing a services which has been used for business and profession outside India, so it will not be taxable in India. This is the first thing. Second thing, which the explanation was introduced in 2012, which says that for rendering any services relating to FTS, fees for technical services, interest, and the royalty, the rendering of services in India is not necessary. These are the 3 things which has been discussed in this judgment. So first thing was that there was a divisible contract. So that means it was a composite contract. So the first point was that if I am having a P, so that means all services or all the profitability should be taken from the Article 5 itself. So that means all earning or all profitability should be connected to the P itself. This was the first contention by the assessee. The court observed that Article 5, which is a permanent establishment, neither serves as a head of taxation, nor does it concern itself with the categorization or classification of income. Rather, Article 5 is specifically concerned with defining the concept of P and enumerate the criteria in which the non-resident entity's presence and activities in the contracting state would be sufficient to constitute a P. So Article 5, existence of the P doesn't mean that all income should be taxable in the Article 5 itself, right? So this is the first observation which has been given by the court. It is pertinent to note that the DTA characterizes profit and income under various independent articles, like Article 6 defines about the taxation from the immovable properties. Article 7 speaks for the business profits. Article 11, 12 talks about the royalty and the FTS. Article 5 doesn't extend to categorization of income, nor does it prescribe the specific article under which such income should be taxed. The article role is limited to defining the circumstances under which a PE could be said to exist and doesn't extend to subsequent tax treatment to income derived from the PE activities. So that means Article 5 doesn't tell about how the taxation would be for a particular item. Or in the alternate way, we can say that Article 5, if if suppose a P in India exists in India, it doesn't mean that it will tell about in which category the income would be taxable in India. This is the first thing. So Article 5 tells about the existence of the P in India, whether it's a fixed P, service P, day, or like. So this is the findings by the court for the Article 5. Second thing, Article 7. Article 7, which is basically on the allocation of the business profits in India for the P purpose. So Article 7 is not intended to be an overriding or a non-abstent or an umbrella provision which would eclipse all other independent articles of the convention. This is evident from the para 9 of the Article 7, which tells about that if a particular line item has to be dealt with the other articles. So this article of 7 will not define those articles, meaning thereby that if suppose a royalty, if a particular item of a royalty or an interest or a fees for technical services has been defined in Article 12 or Article 11, so Article 7, Clause 9 will not override the Article 12. So that means the nature of item, nature of income would be royalty. So that means the taxability would arise under Article 12 or 13, right? So Article 7 will not come into play. So article pertaining to the business profits apply only till such time as the revenue earned by the non-resident entity doesn't pertain to categories of income which has been covered by the other articles of the DTA. Article 7 is pertaining to income generation. The special articles of the DTA lay emphasis on the economic character of the transaction. Para 9 clearly tells about where profits earned may comprise of more than one item of income, which would consequently require the taxing authority to deduce and identify the most appropriate articles under which the item of income would be liable to be categorized. Thus, it is unable to sustain the submission of the cess. So that means mere existence of the P or by fulfilling the condition of the Article 5 doesn't give a right to the assessee to tax all the income in the Article 7 itself, wherein a particular other items like the royalty FTS has been given or has been specified in the different articles. Those articles will govern for that govern for the taxation of a particular item, like the royalty will be governed by Article 13, or the FTS would be governed by the Article 11 or 12. So court has trying to give an interplay of Article 7 and Article 13. The provision of paragraph, see Article 13 tells about the royalty part. And the Article 13 says that the provision of the paragraph 1 and 2 of this article means Article 13 will not apply if the beneficial owner of the royalty or fees for technical services, being a resident of the contracting state, carries on the business in the other contracting state in which the royalty or fees for technical service arise through a permanent establishment situated therein. So Article 13 says that, okay, if it is connected through PE, so that will be taxable under the Article 7 itself. Article 7, para 9 says that if a particular item is to be taxed in a different article which has been specified, like in royalty or the FTS, so that will be taxable under that article. So that means Article 12 or Article 13. So court has given some finding in which way both the connections would be there, whether the Article 7 or whether the Article 13 will play into the picture, but has not given a clear finding on that point, but has given a clue how the Article 7 and Article 13 will come into play for a particular taxation of the royalty or fees for technical services. The second thing which the court observed about the make available. So in that scenario, some research paper or some advisory was given to the BCCI for conducting the IPL matches. IPL matches was conducted in Dubai and South Africa, which is from outside India. The first question was whether the advisory services would be in the nature of the technical services. We can say that the whether it it can meet the criteria of the make available. So court has given a very good findings relying on the De Beers judgment, Biorat, right? So let's find some findings from this judgment, how to meet these make available clause. So court held that mere furnishing of services would not sufficient and a liability of tax would be triggered only if the technical or consultancy services were coupled with the transfer of the expertise itself. If I'm using a particular technology, that doesn't mean that I am being unable to apply the technology at my own. This is the first thing. The make available must be construed as an enablement, conferment, or knowledge, and which would lead to the pair becoming skilled to perform those functions independently. If after applying the technicalities, if I can prove that, okay, I can apply that technology independently. So that means I can say that the technology has been transferred. So relying on the Biorat judgment, it was held that the real test would be the transfer of the technical knowledge and skills and expertise of the provider being absorbed by the payer. So that means some technology should be given wherein the independent application of mind or wherein the recipient can prove that, okay, I can apply that knowledge, apply that technology independently, right? The tax is not dependent on the use of the technology by the recipient. Suppose I am using a particular machine or particular laptop, particular software. Would it mean that I have taken the knowledge, or I am being unable to apply that technology at my independent? So that need to prove by the department. So mere usage or utilization of technical or consultancy material in the aid of business would not sufficient to attract Article 13 of the DTA. The continuing provisioning of services. Suppose if I am using a services on continuous basis, so that means I am not become an independent to apply that technology, right? So in the Biorat judgment, it was held that if you are using a particular services, or if you are taking a services from the other company on regular basis, that means the technology has not been transferred to the recipients. So we can say that the make available clause has been met out. The third thing, the court has done an interplay between section 9(1) clause 7 and the explanation of section 9. The IPL matches was conducted in outside India. So that means the services was provided outside India. The court held that if an advisory services was providing outside India, matches was conducted outside India, the clause says that if a person is paying to the other entity outside India for the purpose of business or profession outside India, the exception would get attracted and the taxability would not arise in India, as per section 9(1) clause 7b. There was an explanation which has been introduced through Finance Act 2012, wherein it was held that the rendering of services would not be mandatory in India. So in that case as well, the rendering of services is not mandatory. So that means the taxability would get a rise. Now the question is, which one override each other? The court held that the section 9(1) subsection 7 is a specific section, is an exception section. If I am using that services for my business or profession outside India, so that means the taxability would not get a rise. So this section was introduced in 1976 and the explanation was introduced in 2012. So that means the explanation can't override the main section. So that means if I can prove that I am providing I am making a payment to the other for utilizing services for my business or profession outside India, the taxability would not arise for the non-resident. So in that case, the court held that whatever the amount was paid outside India for this IPL matches for advisory services, that will not be taxed. So court has categorized into three ways. First thing is that how Article 5 and Article 7 will come into play. Mere existence of the P doesn't mean that the taxability would arise under the Article 7. This is the first thing. Second thing, the court held that if it's advisory services, we need to meet out the make available clause. The second thing. The third thing which the court held that, okay, we need to analyze if the services are rendered or services are utilized for expanding my business or profession outside India, the taxability would not be arise in India. So these are three things which has been held by the Delhi High Court in this judgment. The fourth one, Telstra Singapore. So Assessi was a Singapore-based company. It has entered a agreement with the telecom operators for providing bandwidth services or the roaming services. All infrastructure was based out in the Singapore. So this is like an agreement for providing the roaming services, right? So suppose the Airtel or the Idea or the Vodafone will pay to the assessee like the Telstra for whosoever went to the Singapore or the other countries taking the services of the Singapore telecom operators. The payment will be made by the Indian operators to the Singapore operators, right? The question was that whether the bandwidth services would be taxable under the Indian Income Tax Act or not, provided all infrastructure and all facilities was based out in the Singapore itself. The department held that, okay, it's a taxable. In what scenario it will be taxable and in what scenario it would not be taxable? Let's take a look over this judgment. Section 9, clause 6, which tells about the royalty part. I have given only just the relevant extract of this section. The explanation 2, which tells that the transfer of all or any rights in respect of a patent, invention, model, design, secret formula or process or trademark or similar property. If I am using a services for this secret formula or process, it would be a royalty under the Indian income tax. The clause 4A says that the use or right to use any industrial, commercial or scientific equipment, but not including the amounts referred to in section 44B, BB. So we need to keep in mind the bold part only, the secret formula or process, use or right to use, right? These amendments by explanation 5, 6 was introduced 5 or 6 years back, I think to 2012 onwards, wherein it was held that by introducing the explanation 5, for the removal of doubt, it is hereby held that the royalty includes and has always included consideration in the respect of any right property information, whether or not the possession or control of such right property is with the payer, or the location of such right property information is in India, right? So this was the explanation number 5. Explanation 6 was added just to clarify that the process includes and shall be deemed to have included transmission by satellite, whether or not such process is secret or not, right? So explanation 4, 5, 6 was introduced in the Finance Act. So there was an article of Article 3 under the DTAA, which tells that if any term not defined in the treaty, the reference can be taken from the relevant act of the contract state, means the Income Tax Act, we can take the reliance. Whatever the term has not been defined, so we can take reliance on the Indian income tax. So this is the Article 12 of the Indian Singapore DTA. It has been wrongly mentioned Article 3, it's Article 12. So Article 12, the definition of the royalty is same with the Indian income tax, except two or three things. It has been mentioned that the use or right to use, the bold part is the second part is the secret formula or process. Indian Income Tax Act, the explanation 6 was added whether the process is secret or not. This is the first thing. By making by giving an explanation of by making defining the meaning of the word secret or not secret, and defining the term process as well, right? So changes was happened in the Indian income tax, but changes there was no changes in the DTA. The question was raised whether the unilateral amendment made in the tax law can be taken as a changes in the DT itself. The court held that this was the first thing. The court held that whatever the relying on the judgment of the Asia Satellite and New Skies by this Delhi High Court, the court held that unilateral amendments made by the Indian government in the income tax can't be taken effective into the DTA. So that means we can't say that on unilateral basis changes has been happened in the definition of the royalty. The same can be happened in the DTA. So the court has rejected the uh, the arguments of the income tax department. And in the engineering analysis, the Supreme Court has also held the same thing, that the unilateral changes in the case of the taxation of the software royalty, the court held that the explanation can't be read into the DTA itself. So unilateral amendments can't be introduced into the DTA. This is the first thing. The second thing was use or right to use, right? Use or right to use, as we stated in the definition of the royalty in section 9, use or right to use. The court held that what is the meaning of use and right to use? In that scenario, the infrastructure was there in the Singapore, right? So we can say that the court held that the use right to use means the effective control. Physical control should be there. Wherein I can say that I can make my decision at my own way. Mayors, by making a service of the bandwidth services wherein the infrastructure was based in the Singapore, I can say that it's a use by me, effective use by me. But in the Indian tax, the changes has been happened by making an explanation of 5, which says that whether the control is in India or not, right? But the meaning, the interpretation of the use or right to use means that it should be the effective use, right? So as mentioned in the OECD and the UN commentaries. So that means the use or right to use should be on the effective one. By using a services, only using a services, it can't say that it falls under the definition of the use or right to use. This is the second thing. The court has held that. The third thing is that the meaning of the process. In the Indian tax law, it held that the process means it's whether it's a secret or not, right? But by taking a reliance of the interpretation, rules of interpretation, the court held that the process being liable to be construed by taking an adjustem generis, taking a rule which says that the process has to be taken a meaning of copyright, invent, patent, which has been held in the clause itself. So that means the process should be for the IPR, interrelated personal services, intellectual services. So in that case, we can't say that if I'm using a bandwidth services or telecom services, I can say that it's a copyright services. So court has rejected the contention of the department itself. The fourth thing the court has analyzed that, okay, in the Indian tax, it has been defined that the process is secret or not. But in the DTA, it was held that it should be secret one. The department held that the whatever the under Article 3, subclause 2, it has been held that if the term has not been defined, we can take reliance from the Indian income tax. So process has been defined by making of telecom services, amplification, satellite. The court held that royalty process is not a term, first of all. So we can't say that we can take reliance of Article 3. Process has been defined. Royalty is a term. Process is not a term, right? The court has held that. So conclusion was that unilateral changes can't be made in the DTA itself. This is the first thing. Second thing is that if the process should be there, it should be for the copyright or the IPR or intellectual property rights. So in the telecom services, we can't say that's intellectual property rights. So these are the findings which has been held by the High Court. The bandwidth services will not fall under the definition of the royalty. So no taxability would arise under the Indian Income Tax Act. So we are running short of time. So this is the last judgment. I can take just 2 or 3 minutes just to have some uh, uh, give a brief of the Tiger Global International Holding. I will take not more than 3 minutes for this judgment. See, that judgment was based on the Indian Mauritius Treaty, right? So, couple of things was decided by this court. First thing was that whether a mere establishing company in the Mauritius would it be treated as a conduit or shell company? This is the first thing the court held that. But under what condition it can be treated as a conduit or a shell company, and under what condition it will not be treated as a conduit or shell company. This is the first thing. The court held that mere establishment of the under the Mauritius, it can't be said that it's a mere conduit or a shell company, because whenever the Mauritius Treaty, Indian Mauritius Treaty will get applied, department taking a reliance that okay, it is a shell or conduit company. The court has given a very clear-cut finding. This is the first thing the court has held that. Second thing, the court has held that TRC, because TRC would be sufficient and conclusive proof for taking a benefit of the treaty under this Indian Income Tax Act. Because the department has rejecting the TRC, because the TRC has been given by the revenue authorities of the respective countries, and the court held that under this treaty has been prepared under the political motivation level, political level, not at the executive level. So TRC would be upheld and will be a conclusive evidence for taking the advantage or taking a benefit under the DTA. This is the second thing. The third thing which the court has held that beneficial owners, meaning of the beneficial owners. The court held that beneficial owner means who can freely decide what to do and what not to do. If there is a legal obligation to transfer, suppose a company has been set up in the USA, main company, and they have created a subsidiary in the Mauritius, and through Mauritius, some investment was made in the India. So by applying this Indian Mauritius Treaty, if a company is established in Mauritius, we have to prove that who is the beneficial owner. Beneficial owner means that if suppose a Mauritius company, there's no legal obligation to pass the benefits to the US company, so I will be treated as a beneficial owner, means the Mauritius company. If there is some obligation to transfer the dividends or transfer the funds to the US company, that will be treated as the US company will be treated as the beneficial owner. In that case, the treaty benefits would get denied. So court has defined the meaning of the beneficial ownership by taking a reliance of the DTA and the UN commentaries and various authors. So the court has defined this concept. The fourth thing the court has defined that if a company is fulfilling the conditions of the LOB clause, limitation of benefit clause, which under Article 27A of the DTA between Indian and Mauritius, we can't say that we will deny the benefits to the Mauritius company. So by taking a reliance of the LOB, TRC benefits, the court held that all benefits under the treaty would be given. So that was a very conclusive and very thoroughly judgment, 200 plus pages of this Tiger Global. So I have made my uh, uh, made up this session. So if there is any questions, so please let me know. There's a one question. DTA with Cyprus says in the protocol that capital gain in the shares acquired before will be taxed only in the country of residence. If a person inherited shares from his late father in 2012, but shares was acquired by the father before, can the son gets the benefit of this clause in the protocol? See, these are very specific questions. The inheritance, the shares were transferred from father to son, and if the benefits can be treated by the son or not. So it's a very peculiar question for taking the benefits uh, between the particular country. So from my opinion, so the father would definitely would get the benefits, but we need to check whether what the law tells about or states about the inheritance between the father and the son, whether it's allowed or not. The next question is whether Form 10F is also mandatory or TRC will for claim. Some uh, amendments was introduced in 3 4 years back, wherein it says that TRC would not be TRC would be sufficient, but we need to give some other documents as well, uh, uh, which has been defined in the rule itself. So TRC is mandatory, but apart from this TRC, we need to give some other documents as well for taking the benefits under the DTA. I think this amendment was made in 2 or 3 years back, right? So any other questions? Okay, thank you very much to all the participants.